Looking at the circumstances right now, do you think that is a special case, and do you think there is the possibility the Supreme Court will grant that leave for new evidence to be submitted?
We cannot say for certain what the court will do. It will depend on what is being pursued. For instance, if it's about questioning qualification, just as you said earlier, the conditions for qualification are spelled out, and in the interpretation section 318, the requirement for that office is given in very generous terms. It's as good as having primary school certificate and having worked in any place, private or public, for a period of 10 years, or having attended courses and all that for a cumulative period of 1 year. Nearly anybody will meet any of those terms. So it may not be useful in that sense. If it's for disqualification, you remember the position of the Court of Appeal was that that's a pre-election matter that should have been filed at the appropriate time, which is not later than 14 days after primaries and all that, saying that any other person who is also not a member of the party, who is not an aspirant to the primary from which a person was nominated, is an interloper, is a meddlesome interloper in what is not his business. However, if it is possible to pursue that ground of disqualify the candidate because he said something under oath that is not true, they just might be able to persuade the court to consider additional evidence in that direction. It remains to be seen whether the court will accept that disqualification question at this stage.
Professor, is there any part in the Constitution that says the president must reveal everything about him?
No, all that the Constitution requires is that you present your proof of qualification, and that's why blaming INEC is difficult. You recall that the president has been senator before.
Okay.
Let's say he was senator for 4 years. He has been governor for 8 years.
Okay.
That's 12 years.
Yeah.
He has held very senior public offices that more than qualifies him for one who can express himself in English language and possibly has had primary education or school certificate. Remember, the Constitution keeps using or its equivalent, so it's not specific to the certificate. So you can't blame INEC for that. Secondly, INEC again is allowed to satisfy itself whether a person, what the person presents is satisfactory in the case of something lower. The last part of that interpretation, it says, or such any other certificate, any other qualification that is approved by INEC. So it's very fluid and very open. So it's difficult to blame INEC in the circumstance. I think the question that all this is raising is whether somewhere along the line has been a perjury and what should be made of it.